On daily list, item number 1.
That was that bill matter on the last
May I
occasion.
be please, Your Honor? Your Honor, I'm praying that this item may be come up at the end of the cause list, Your Honor. The
My
counsel
lord,
is
in
there.
that case, my lord, I have got plenty of matter there.
No, what?
Tomorrow.
Why?
This is NDPS case, my lord. This is for bail. My lordship will remember on the last occasion, they were even given the preference of appearing through VC also. So, my lord, that is the issue. My lord, I have got lots of hearing matter. We'll have it tomorrow, otherwise.
Oh, what?
Here the petitioner was driving the vehicle, my lord, that was involved in my lord drug, my lord, transportation. He is the driver, my lord. And my lord, if his 161 statement is produced, my lord, he reveals that he was hand in glove and he was a part of the, my lord, the gang. And that apart, my lord, he had been doing it since last 2-3 times, my lord. That is
What is the stage of the case?
stage of the case. So far, I know, my lord, it is charge sheeted.
Agitated?
Trial has not begun.
I don't have any instructions, Your Honor.
You're not
I was
appearing?
just, no, Your Honor. I was just instructed to ask for the keeping
Time.
this matter at the end of the board because they were stuck and the counsel was coming from Clarion.
They were given the preference to appear through VC also, my lord.
If he comes, if he has, you see,
It's already.
if he, if he has tried to come all the way from Clear, why should we?
That is there, my lord.
almost here, Your
I also have difficulty, my lord. At the time of that, my lord, I'll be busy in the hearing also, in the other courtroom.
We'll see, Mr. Govind. Try
lord, my lord, yes.
try to make time.
My lord,
Bail matters usually, it's not.
My lord, yes. I'll make
Probably we don't adjourn it unnecessarily.
my lord.
Only if it's required.
My friend is asking the time, my lord.
He said at the end of the board.
My lord, we'll make an attempt, my lord.
Will we?
Highly obliged, Your Honor.
Item number 2.
Let this item also come at the bottom of the list, my lord, because it is a hearing, my lord. I was hoping if by that time Advocate General is also free, he's so otherwise he can start. And
Mr. Burrow is here. You can start.
he can start.
Because if if I recall, matter has been heard.
Yes, my lord.
Just for the refresh.
Argument have been filed.
Yes, my lord.
Just to go through the brief facts of the case.
Absolutely.
Hardly take 2-3 points only. I'll just argue the matters.
I think
So, my lord, bottom
let
of
him
the list,
let him start and we'll.
if some other matters.
Why? Where's the AG? AG is where? Where is he now?
He's on legs, my lord. I was told that he'll be busy for another hearing. That is why I made a request that otherwise he has instructed me to take up if he is not available to start, and I have been given instruction to do so.
Oh, see, unnecessarily keeping the matter pending.
Yes, my lord.
This matter is quite.
You start, Mr. Burrow. We'll see. And Mr. Singupta, you can also.
Yes,
you are well briefed in the matter, so.
Yes, my lord.
In fact, I have also taken some notes of your argument, so I may recall whatever has been.
Shall I start? Yes.
And you. Please.
Yes, Lordship. I'd just like to take this affidavit filed by the petitioner, additional affidavit of 23rd August 2022. That is the inception of the sawmill. Yes.
Dated?
Dated 23rd August 2022. That is the inception, additional affidavit to bring on certain documents to ascertain the inception of the sawmill of the petitioner.
It's a copy, yes, sir.
23rd August
20th August 2022.
22.
There is a page 6, Your Lordship, annexure B1. Your Lordship, in this letter, just item serial number 2, that is the Srimati Bislina War Pasa Mimintudu. So that means what is the present existence of the unit? Okay, it was prior to this, it was situated in the Mimintudu. Okay, so the subject is the proposal for allotment of land at industrial estate Kretirchi. That is way back in 1999. The land is already allotted to. With reference to the subject mentioned above, I am to inform you that for allotment of the land at industrial estate, you are first desire to apply for a provisional residence certificate to General Manager DIC GY. Okay, this letter has come in consequence to page number 8, annexure B3.
Annexure B3.
B3. That is shifting of sawmill cleared by the HPC High Powered Committee to notify neutral state. In view of the CFME having clarified indisputably through its letter dated 2/6/2004 stating that those sawmills cleared by the HPC, that is including the sawmill of the petitioner, which was situated in the Mimintudu, may be allowed to shift to industrial state to establish their machineries at the allotted site. You are hereby directed to shift your machineries and equipments pertaining to the sawmill to the plot allotted to you within 15 days of receipt of this letter. The issue as per the direction of the Honorable Supreme Court. After the action of the Supreme Court has been directed that shift to the present industrial state. Okay, they have done accordingly. Then thereafter in the next page, Your Lordship, page 10. There is the grant of license.
Yes.
Okay. The grant of license in respect of the Srimati Bislina War Pasa. Please find the enclosed copy as a copy of the government approval dated so and so. You are hereby requested to fill up the enclosed application and remitting an amount of rupees 10,000 to the Treasury challenge for granting the license. The same is to be forwarded for Principal Chief Conservator for us forth with this office. In the next page, Your Lordship, that is the license, initially which is issued. Page 11, annexure B5. That is the license issued by the Forest Department. So from this submissions, it is clearly proved that the petitioner unit was existing right from the Mimintudu. Thereafter, it will be shifted to the present location. Okay. Thereafter, another affidavit, Your Lordship, that is also 23rd. That is 17th May 2024. Additional affidavit to bring on renewed license to run sawmill, because the license has been renewed every year after paying the necessary fees to the Forest Department. That is affidavit dated 17th May 2024. Which is issued on, that is in page 5, annexure C1. That is the license dated 23rd December 2022. Even after filing,
Renewal.
renewal, yes. Even after filing this petition, the license has been renewed every year by the petitioner. Because if he doesn't renew the license, that his lease agreement will come into effect.
Yes.
Your Lordship, then come the next affidavit. That is the affidavit dated 23rd August to again 22. That is an affidavit by petitioner to bring on record the type. Yes. There is another affidavit, Your Lordship.
Dated?
Dated 23rd August. A small affidavit.
23rd August 2024.
2022.
2022.
2022.
Oh. This is
This is regarding an affidavit by the petitioner to bring on record the type copy of the annexure A1. In our rejoinder of one of the respondent, we have given a copy of blueprint.
okay.
Okay, this is not, it is a readable. So for that we have to give the type copy. So type copy in the next copy, page number 4. Sorry, page number 3.
This one.
Now, below in the right hand side of the type copy, yes,
Page 3 or page 4?
this is page 3, Your Lordship. There's just a mistake. Page 3, Your Lordship. Just a small affidavit of 2 pages.
You have marked it page 4 here.
Oh, Your Lordship, I am obliged for that.
Yes.
Yes, below in the right hand side, you can see, Your Lordship, countersign on 4/5/2007 by Deputy General Manager, Technical, Meghalaya Industrial Development Corporation, who has allotted me the land. That means I submitted my blueprint to the concerned authority. They have come to countersign after preparation. It is in the lease agreement is clearly written. Okay, all the proposals should be given to the things. Okay, they'll approve. Then you can start the things. And moreover, when initially it was in Mimin to do, all my machines were there. So definitely when the land is allotted to me, definitely I have to have a setup. Okay, so that means we can understand there is a continuation of what is going on there, because it is not that we have been removed from there. It is on the direction of the HPC, on the pursuance to the Supreme Court cases, we have been shifted to the new industrial estate. Okay, so I have to come along with all my machineries. I have to set it up there. Even after when the lease agreement was signed, it was clearly written that all the plans should be given to the concerned authority who can approve it. So it is already countersigned by the thing. Is given to the whom? To the authority who has allotted me the land. So this is how the inception has come. My unit has come into existence how? From the initially till the present. Now, Lordship, I'll take it to the affidavit of respondent number 4 and 5.
Dated?
There is a affidavit of opposition by the respondent 4 and 5. He has written 13th December 2018.
Thirteen
13 December 2018. Affidavit of opposition by the respondent 4 and 5.
This one.
December 2018.
Yes.
Yes, Lordship, the page number 7, annexure 1. There is letter dated 22nd May 2007.
Page 7.
2007. Here the respondent 4 and 5 has written to the DIC for construction of the KV line. This is 33 KV line. Look at the content.
His letter dated 22nd May.
22nd May 2007. I'll just read the content, Your Lordship.
Yes.
Subject is the construction of 33 kV line from Kletirchi village to the Narthiang village. With reference to the subject cited above, I am pleased to inform you that the Meghalaya State Electricity, then now the MECL, will soon start the construction of 33 kV line from Kletirchi to the Narthiang village. The aim of this project is to improve and maintain the stable power supply to your area. In this connection, the board needs your full support and cooperation so that the construction work, once taken up, not be interrupted or disturbed for the smooth and timely completion of the subject. Your sincere support and cooperation would undoubtedly help us to speed up the construction work for the interest of the board in the particular and the people of area in general. So this is the only letter the respondent number has 4 and 5 has brought before this court, where they asked for a cooperation. But in subsequent to this, or in relation to this, there's no such letter has been ever issued to the respondent 4 or 5 by the respondent 2 and 3, the DIC, that you have been allowed. This is the only letter, whereas they just sought help, but the state was never given the things. This is the only letter they have. So, Your Lordship, I like to come there. This amended petition, Your Lordship. Amended petition 14th March 2022.
Yes.
Page 14, Your Lordship, Annexure A1. Page 14. Annexure A1. Here the General Manager DIC has written to the E distribution joy. The subject is shifting of 33 kV line, HT line. Sir, with reference to the subject cited above, I have the honor to request you to kindly shift the power lines located in the compound of the petitioner, that is BW Pasa Gambinier Mills, Industrial Estate, Kalitrichi Joy, which is very close and posed a great danger to the nearby constructed shed. This is the one letter, Your Lordship, which is written. Another letter is at page 18, Your Lordship. Annexure A4, page 18.
Yes.
This is written by the Director of Commerce and Industry to the Executive Engineer, MECL. Subject dated 6 October 2016. Shifting of 33 kV and 11 kV lines administrator Kirishi. Reference number so and so. Sir, while referring to your letter dated, that means they have written to the government. Okay. All these corporations and all. Before filing this petition. While referring to your letter data cited, I am here to reiterate that 33 kV and 11 kV lines which passes through the Kalitrichi industrial estate in general, even in general they said, not just to the thing. In earlier letter they said that it is posing as great danger in relation to the petitioner's unit. Now he is saying the in general. And industrial unit of MS Bislina or Pasa sawmill, Convener in particular, were constructed without obtaining prior permission. This is the need to be seen. That means they have no authority, no permissions granted ever to them. Prior permission from this department. As such, it is incumbent upon the corporation to shift the lines at its own cost. Question of payment by this department or the unit. Department and the unit. Unit means the petitioner's unit. And the department, they have no role to play. It is you who is entered illegally without obtaining any permission from the concerned department. And now you are asking us or from the unit, it is not justified. Your Lordship, another page 8. Page 23. Annexure A8.
Yes.
So that is also 29th November 2017. Thereafter, another letter again to the EE, to the MECL by the Director of Commerce and Industry. This is Director of Commerce and Industries. Same thing, shifting of 33 kV line at Industrial Estate and Kalitrichi. Kindly refer to your report of the joint survey. They have gone for the joint survey, where the petitioner was not made the party. They have done by themselves. Shifting of 33 kV line, Wager, D circuit line at Industrial Estate Kalitrichi conducted on 10/3/2017 jointly by Sri H Law AE, Sri D India JE, Sri T Poi P Toy, General Manager DAC Juai, and Sri G Lingdo, Assistant Director of the Cotton Industry Juai, wherein inter alia had termed the construction of the building of MS Bislina Pasa come within the state as illegal and also recommended for shifting of the line. On perusal of the report and available document, it is found that the MECL has not obtained the NOC. He also saying that in 3 occasions, the government has taken the stand that they have never obtained the NOC. It is found NOC, permission from this department for construction of so-and-so line passing through the electricity industry. Joint inspection team is not the competent authority to declare any building or construction as illegal or illegal. So that means the inspection they've got done, joint survey, that is, has no validity in law. In view of the facts, report submitted by the terms is therefore not acceptable. The MECL who has trespassed into the land should be shift the line to a safe place, and providing right way and expenses required thereof for shifting of the line is the sole responsibility of MECL, being the service provider. It may also be noted that the service provider will be answerable for any untoward incident arising from the HT line. So that means in all the letters communication, Lordship, right from the inception of my thing, my inception of my university came into existence through the many process. All the letters communicated, we have obtained the permission, we are paying the license fees, we are obtaining the license, and they have only one letter which is they have written in 2007 for a cooperation. In consequence to that, nothing has been in their favor, but still they said no, our building is illegal or something. Now, Your Lordship, I will come to the affidavit in opposition by the respondent 2 and 3. Respondent 2 and 3, that is dated 9th July 2019.
Yes. 2019.
2019, and page number 12, annexure 2.
Yes.
Here how the state has shifted their goals. At one point of time, in 3 communication, they said that respondent 4 and 5 has illegally constructed the line. Now how they have shared the things, and look at the letter dated, Your Lordship, 8 July 2019, just one day before filing this affidavit, and after filing our petition. That is, there is afterthought. Look at the content. To the executive engineer by the same Director of Commerce and Industry. Subject shifting of 33 kV line at the industrial electricity. On re-examination, this to be noted, Your Lordship.
Yes.
The matter is already pending here. Of the earlier communication issued by letter dated so and so 2/9/2007, which is the part and parcel of my amended petition. That is annexure A8 to page 23.
Yes. Yes.
Taking into account that then MECB, now Meghalaya Power Distribution, has sought cooperation for all concerned authorities, including this department, prior to the construction of cable line, which passes through the electricity estate, Jaintia Hills. Construction of the line is meant for the uninterrupted, they must have done the mistake here in spelling, supply of power and for the larger interest of the public. Letter dated 29/11/2017, where in that letter they said that survey was illegal. They have trespassed into the land of the
That
petition.
letter was copy was given to you.
No, this copy was this copy.
Earlier letter. This.
This copy.
29,
Yeah,
11.
addressed to me. He has the copies there, but this is came in their affidavit.
No.
In their affidavit.
When see this 29/11/2017.
Oh, that is yeah. We have annexed in our petition.
So that copy was given to you.
That copy was given to me. So now that.
And now this copy of this letter was not given to you. When that letter was cancelled.
That letter it does.
By this
letter.
No copy was given to you.
The copy is here.
Oh, copy was given.
Copy to me.
Oh yes.
But this is came in their way of affidavit. So I'm arguing on this matter.
Okay.
So the 29/11/2017, which is part and parcel of my petition, which is my entire case was based on that letter only, those 3 letters. Now all of a sudden they've come, they've withdrawn, they've changed their stand. On what basis? Re-examination. That means in 2007 they asked for the cooperation. In 2019, that means after 12 years, they have realized that yes, you have to reconsider it. That is what came on the way after we filed this petition. That is afterthought we can make it. And the letter also just day before they're filing the affidavit. So this is how the things are. So what is my humble submission is that even in my written argument, in written submission, the similar issue was decided by the division bench of this honorable court. Okay. Whereas in that matter, the line was already existed right from 1968. Then the go down of that LPGS came later, but still court has directed to shift the line because it's posing the great danger. But in my case, I'm already in possession. I'm already doing my business. They have came in between without obtaining any permissions. Now they are asking me to, even they are asking us to pay the necessary amount to shift the line. So where is my fault? My unit is lying vacant, no activity is going on. I have the liabilities, bank liabilities. I have taken because once you start such a big unit, you need a financial support. I have taken the loan from the loan. The loan has all become NPA. So what do I do in this case, Your Lordship? So this is my humble submission is that they may be directed to shift the line and to pay the necessary compensation right from the day the unit was affected.
My lord, my lord, what I could gather from my friend's submission is that he's trying to give the image that there is a conflict between the industries and the MEPDCL.
Yes.
Subsequently, my lord will recollect when Learned Advocate General was appearing, my lord, saying that there is actually no interdepartmental conflict. So he wanted to set the letter straight, and thereafter, my lord, they realized and they passed that cancellation order saying that this issue of you issuing NOC or not seeking NOC and all, since your letter is there and we have given our nodal approval for everything, so we cancel our objection and everything.
See, Mr. Sengupta, as has been pointed out, now I realize you have passed the cancellation order.
Yes, ma'am.
But that order is sub judice.
It is sub judice, but then, my lord, it was a corrective measure, my lord, in the process, saying that the moment we realize my lord, continuing with the wrong would not help us in any manner.
What you should have done is, on the allegation of the petitioner, you should state your stand, but you cannot change your stand. I think that principle is very clear.
That principle, my lord. My lord, we have given a written submission, my lord. My lord will kindly take my written submission, which was placed by Learned Advocate General, my lord.
Yes.
Common written submission on behalf of the respondent, my lord.
Yes.
My lord, the petitioner seeks to raise the following contentions at the outset for dismissal of the instant writ petition. The instant writ petition is not maintainable in facts and in law. The instant petition has been filed with petition by suppression of material facts inasmuch as the lease deed executed by the petitioner and the answering respondent have been withheld and not made part of the writ petition, my lord. The claim is also against the Electricity Act and statutory provisions. D. The writ petition raises the disputed questions of fact. Finally, it is also barred on the ground of delay and laches, my lord. My lord, the para 2, my lord, the petitioner in the instant writ petition has prayed for direction of respondent number 4, that is the executive engineer Joy distribution, and respondent number 5, assistant executive Joy distribution subdivision, to shift the HT line at the land of the petitioner at industrial area Clatesry and sought compensation for loss caused to him. My lord, the preliminary submission on maintainability, it is submitted that the petitioner has concealed material facts from this court inasmuch as the petitioner has failed to place the lease deed dated 17/9/2012 entered between the Director of Commerce and Industries and the petitioner containing certain terms and conditions. The salient provisions of the aforesaid deed, which is important for deciding the matter as stated hereunder for ready reference. My lord, we have quoted it, 7 in that lease deed, that the lessee shall not erect or build or permit to be erected or built or permit to be erected or built on the demised premises any building, sheds or other construction other than those approved by the lessor and or his agent authorized, nor make any subsequent addition or alteration to the existing building and shed at any
time except with the written approval of the lessor or his authorized agent. That in the event of the lessee fails to comply with the terms and conditions hereto set forth, the lessee shall be automatically terminated with the right of the lessor
See,
to...
Mr.
Yes, my lord.
Sorry to interrupt you.
My lord.
But this, you see, you are referring to the lease deed
Lease deed, my lord.
purportedly violated, the condition of which have been violated by
the petitioner.
But you see, that would be a different cause of action altogether. If the lease deed is violated, if conditions have not been fulfilled, you have a right to proceed against the petitioner in another proceedings. Here is the cause of action is totally different. We are not talking about the validity of the lease of the petitioner. What we are talking here is the obstruction caused to the plant and machinery of the petitioner. You see, in due course, if you find that the lease
Has
been
expired
violated,
or
then
any terms has
you
been
take your
violated.
action, you take necessary action, but not.
This is
not
one
like
of our
that.
submission, my lord. This is one of our
That would
submission,
not-
my lord.
Anyway.
That number 4, my lord, that it submitted that white letter dated 29/4/2014. This honorable court made a pointed query regarding permission of this relates to the construction, my lord, of the sawmill on the aforesaid premise. It is further submitted that the petitioner has filed the additional affidavit dated 16/5/2024, and in the said affidavit, petitioner has failed to show permission by the Director of Commerce and Industries, Government of Meghalaya. Therefore, the petitioner is in illegal possession of the aforesaid premises. On the ground alone, the writ petition is liable to be dismissed.
What else?
My lord, Para 6, my lord, that it is submitted that Annex 3 of the affidavit of respondent number 4 and 5 shows a report on the joint survey of the official of PDCL and Director of Commerce and Industries showing that illegal construction has been carried out by the petitioner on the said land, my lord.
But
The joint inspection.
But by your own letter, you say that this this joint survey has got no validity.
So, my lord, on the ground, besides this, my lord, we have also stated that in regards to the rules of the high tension, page 8, my lord, the respondent by letter dated so and so of 22/5/2007 has informed all the concerned authorities and persons, that is the manager of DIC, principal ITI, and the headman of Muklab village about the construction of high tension wire 33 kV to improve and maintain a stable power supply for the people. The department had issued the above mentioned notice with a request for cooperation and timely completion of the project. This has been already pointed out by the petitioner, my lord. My lord, para 12, my lord, the transmission lines were constructed in 2007 as essential public utility service following all prescribed rules and regulations. The construction was carried out after informing the relevant authorities, and no objections were raised at that relevant point, my lord, regarding the lines passing through the property of the respondent and within the same property, the industrial units occupied by the petitioner, my lord. So objection was never raised, my lord. So that is where, my lord, the next point comes in, my lord, is that non-compliance of the rules and the petitioner raised objection after about 10 years. 10 years of the construction and requested the line to be shifted. The petitioner has subsequently informed and estimated bills that will be owned by them in consonance, and thereafter, my lord, this dispute started, saying that the authorities are saying that you have to pay the expenses and we'll shift the line. So this has been the position, my lord. So that is what we have stated in our written argument, my lord.
Any authorities?
My lord, pertaining to delay and laches, my lord, we have given mentioned in page 16, my lord, page 14, my lord, we have given the extracts of it also. Yes, my lord.
Lordship, just in respect to the delay and latches, I just like to raise one issue, small. They said that there is a delay of 10 years. What is the last communication to the petitioner? That is 2017, November 2017. whether they said that NOC is not obtained, even they have trespassed. So what do the petitioner do? Basically, they'll wait for all the authorities to communicate. Once the communication is over, nothing is coming, then he'll come before the appropriate authority to file his grievances. In between, when the communication is going on, if I come before the court, even the court will say that first you finish your communication. If nothing is fruitful, then you come up. So I came in 2017 and the matter was filed in 2018. Where's the delay and judges? Question arises.
You have reverted that in your written argument.
I have already waited in my things.
So for the parties?
Yes, ma'am.
Yes, ma'am, sir.
Item number 3.
Pleasure.
May it please your Lordship. Lordship, I'm seeking for some accommodation on this matter, Lordship.
Why?
This matter is being led by Mr. Paul and he is still in bereavement, your Lordship.
No objection, my lord. Where they are supposed, according to us, they are supposed to file appeal, but rather they have filed a revision, my lord. So that was the point to be decided in this case after the conviction, my lord.
Miss Learned Counsel, the petitioner has sought for accommodation on the ground that the Learned Senior Counsel, who is leading the case, on the ground that the Learned Senior Counsel, Mr. K. Paul, who is leading the case, is indisposed. The same not being objected to by Mr. S. Sengupta, Learned Additional PP. Matter is adjourned.
After 3 weeks.
Lordship.
As prayed for by the party, this is matter of the 3 weeks.
Highly obliged, Lordship.
Item number 4.
May it please your lordship. My lord, this matter pertains to non-payment of full and final settlement to the petitioners pursuant to VRS, a golden handshake, by the respondents. Now, my lord,
Which department?
my lord, this is the MEDCL, which is the subsidiary of the MIDC. MEDCL, a subsidiary company of the MIDC. It falls under the Ministry of Industries. Now, my lord, what has happened here is, sometimes in 1986, my lord, the MEDCL,
Yes.
that is the Meghalaya Electronics Development Corporation, was established. It was a subsidiary of the MIDCL, a fully owned undertaking, a fully owned corporation of the government of Meghalaya. Now, my lord, this corporation was engaged in manufacturing, sales and development of and production of tantalum capacitors. Now, for some years, the corporation was running fine. However, after some time, the corporation started running into losses, and accordingly, the government decided that the excess workforce will be relieved by way of a voluntary retirement scheme. So, in December 2005, 42 out of the 59 employees were given a golden handshake. They were given a golden handshake, that means one-time compensation was paid to them, and thereafter the dual relationship between these 42 employees and the employer ceased to exist. However, 17 of the 59 employees, they were retained. These 17 of the 59 employees are the petitioners before your lordship. Now, they were retained with the assurance.
When the scheme was offered, it was voluntary.
It was a VRS. It was a golden handshake,
So, see,
handshake
now
scheme.
The option would be on the employees whether to
Yes.
avail it or not.
My lord, it was, they had to take it, my lord.
They have to, more or less, it should be
In the
then-
garb of a VRS, my lord, they were asked to, some package compensation was paid to them with full benefits of the third pay commission, which was prevalent at that point of time. And after receiving that, my lord, the 42 employees of the then MED of the MEDCL then ceased to the services ceased to exist, and they ceased to become the employees of the MEDCL. However, 17, including the petitioners herein, were retained. Now, they were retained with an understanding that the MEDCL would revive in the near future. They will diversify. They will venture into new sectors. However, that was not to be. In course of time, the MEDCL from a production unit of tantalum capacitors was reduced to that of a commission agent, a sales commission agent of the Steel Authority of India for the period 2007 to 2010. Now, Lord, these 17 employees that that is the petitioners herein who were retained, who were not given the benefit of the golden handshake at that point of time in 2005. Lord, they continued to work. They continued to work till December 2012. They were attending their offices. However, their salaries, my lord, their salaries were paid up to December 2010 at old scales, my lord. By 2000 till 2012, when they were attending offices, by that time the new pay commission, that is the fourth pay commission, had already come into effect. And
the nature of their employment is on a regular basis.
Yes, yes, they are employees of the MEDCL.
And the sanction.
No. Yes. They are employees of a corporation. This corporation is a fully owned undertaking of the government of Meghalaya. It is a subsidiary company of the MIDC, my lord, which is also of the MIDC itself is a fully owned corporation of the government of Meghalaya. So they were receiving regular pays and so on and so forth. Their status is that of a regular employee also, let us say that of a regular employee in any government establishment, since they were employees of a government corporation. Now, though they attended office till December 2012, their salaries were paid only up to December 2010 at old scales. Now, in the meanwhile, what had happened was the respondent government of Meghalaya decided to wind up the affairs of the MEDCL fully. That means to close the MEDCL fully, they decided, and to that effect, a decision was taken, and the process of winding on is on. It is till date, the company is not fully wound up. So when the decision was taken, the management was asked to submit the fund requirement to wind up the affairs and to give a golden handshake to the existing employees. Accordingly, a fund requirement of 2,48,68,789 was given to the government. Now, this fund requirement was based on the requirement as on 31st March 2009. That means if the company was to wound up at that point of time on 31st March 2009, a sum of rupees 2,45,68,789 was to be paid. Now, of this amount of 2,45,68,789, the government released the compensation amount in two installments. First installments of 112.20 lakhs, that is 1,12 lakhs and 20,000, was released in the financial year 2009-2010. Another installment of 1,13 lakhs and 48,000 was released in another financial year, in the next financial year, that which is FY 2010-11. My lord, the compensation which is paid under the golden handshake, or a compensation being paid in lieu of a voluntary retirement scheme, it has to be paid in one shot. Whatever is the compensation on the date the VRS is adopted, it has to be paid in one shot. Now, when it is paid in one shot, upon payment of that of the compensation and upon receipt thereof by the concerned employees, the dual relationship between an employee and an employer comes to an end. However, in this case, it was not so. A compensation was assessed as per 31st March 2009. That too was released in 2 installments. The entire compensation was not released. It was released in two installments of 112.20 and 113.48 lakhs. Now, the respondent 2, which is the Commerce and Industries Department, the Secretary to the Commerce and Industries Department. Now, my lord, it by a letter dated 6/10/2010 asked the MIDC to furnish the fund requirement for VRS with the implementation of the 4th Pay Commission. That means...
But what has that got to do with you?
My lord...
As far as VRS is concerned, you are not connected. Not at all.
No, my lord. The VRS was not fully paid, my lord. Because the...
You are not espousing the cause of those who have opted for...
No. My lord, I am espousing the cause of these 17 people.
Yes.
These 17 petitioners, my lord.
Who have not, availed of that.
No. The 42, they have already received their entire benefit.
Yes.
They have received the entire benefit. These 17 employees who are the petitioners herein, they have not received the full benefit.
You said their services have been retained.
They
continue to be regular.
Yes, they continue to be regular employees. They continue to attend.
Not connected at all with the VRS.
No. They are not connected with the earlier VRS. They are not connected with the earlier. With the earlier set of 42 people who were given VRS at a prior point of time, that is in 2005.
True.
These 17 people, that is the petitioners before your lordship, were retained post 2005, and thereafter, after a point of time, the government decided that it wants to wind up the affairs of the company, and it decided to terminate their or to put an end to their employment by giving them a golden handshake in the form of a VRS. Now, our grievance here is the VRS is not paid in full.
So what you are trying to say is this, that as and when the company was decided to be wound up, you were offered the VRS. Another set of VRS.
We were offered VRS, yes. We were offered a VRS. We had to take that VRS, but however, the full compensation in lieu of that VRS was not paid to us. That is our grievance before my lords. So, my lord, by Annexure 2, by letter dated 6/7/2010 and letter dated 8/7/2010, which are marked as Annexure 2 and 3 in the writ petition. Page number 29 and page 32. Well, I'll just read out these two annexures.
Yes.
Now, my lord, the respondent number 2 wrote to the Director of Commerce and Industries, seeking for a status report on MEDCL Limited. Now, the letter reads as under: I am directed to invite reference to letter number so and so, copy of which has been forwarded to you, and request to submit a revised fund requirement to the government for final settlement of VRS with implementation of the 4th Meghalaya Pay Commission. With the implementation of the 4th Meghalaya Pay Commission. Now, this letter was forwarded to the Managing Director of MIDCL, and accordingly, by Annexure 4, the fund requirement was submitted to the government.
Page
Annexure 4, that is page number 33.
33. Yes.
So, my lord, as per this revised estimate, as per the revised estimate, that is as per Annexure 4, which was given on the request of the request of the government to submit a revised fund requirement. As per this, if the VRS was to be implemented on July 2011, a sum of rupees 2 crores 94.84 lakhs, 2 crore 94 lakhs and 84,000 was required to be given to the employees, to the petitioners, with the benefits of the fourth pay commission. Now, my lord, after the submission of this letter, now, my lord, Annexure 4 was given to the respondent authorities, wherein it was outlined that a sum of rupees 294.84 lakhs will be the revised fund estimate for full and final settlement of the golden handshake to the petitioners. Now, my lord, on 18th April 2011, management, a meeting of the management and board of directors of the corporation took place, and in this meeting, it was decided that the cutoff date for payment of compensation to the petitioners would be fixed at 31st July 2011. This, my lord, will find it Annexure 5. My lord, it reads as under: the director in charge so and so informed the board that the corporation has received so and so from the government, directed the corporation to submit an update requirement of VRS amount. Further, it has also been briefed that the member it has also been briefed the members that the VRS area salary which has been paid to the employees have been worked out till March 2009 only. Moreover, the director in charge informed that he has received a petition from the employees with requirement with request for payment of their salary till March 2011. In view of the above, the board directed the director in charge to work out on the requirement of fund for VRS area salary till July 2011, which is the cutoff date, and to submit to the government at the earliest. Further, the director in charge informed the board that at present the MEDC has no source of income, and as such proposed that all expenses relating to liquidation of the MEDC will be borne by the MIDC. Naturally, my lord, because MIDC is the parent company and MEDCL is the subsidiary company. The board agreed to the proposal given by the director in charge, and as such adopted the following resolution. Now, my lord, this is the resolution adopted on this is the resolution adopted in the meeting of the board of directors held on 18th of April 2011. Resolved that all expenses relating to the liquidation of MEDCL will be borne by the MIDC holding company. Further, the board directed that the director in charge to inform the MIDC on the matter. So, my lord, there it was resolved that all the expenses relating to liquidation of the MEDCL, including the outstanding payment to be made to the petitioners herein, will be borne by the holding company, that is the MIDCL. Now, as per this resolution, my lord, it was decided that the cutoff date for VRS and payment of area salary to the petitioners, to the remaining employees of the MEDCL will be 31st of July. Will be July 2011. That's 31st of July, right?
Yes. 2011.
2011. Now, my lord, despite this resolution, the petitioners were not paid. The resolution was taken. Whatever is the requisite amount was required to be paid to the petitioners, that was also collected, that was submitted. The revised demand was submitted to the government. A resolution was taken that the cutoff date for the VRS and area salary will be July 2011. However, no such payments were made. Despite these resolutions. Now, my lord, as now, my lord, after the fresh after the cutoff date was proposed and accepted in the meeting of the board of directors dated 18th April 2011, and it was decided that the cutoff date for the employees availing the VRS scheme will be fixed, will be July 2011. The government released a sum of rupees 142.28 lakhs on sometimes in May 2014. This was released. So, my lord, what happened was that the payment which was required to be the compensation which was required to be paid in one shot was released in three installments. First installment was released in financial year 2009-10, then thereafter it was released in 2010-11, and then it was released in 2014. However, the entire amount was not paid. Now, my lord, when the government has decided, when the respondents have decided upon a cutoff date, it implies that once you have decided upon the cutoff date for implementation of the VRS, if the entire payment is not released within that cutoff date, the whole idea of having a cutoff date is rendered meaningless. Because once the board resolution was taken, a cutoff date was fixed, so they were required to pay whatever was the outstanding amount on that particular day. They, however, failed to pay it, and they paid it at a later date, that is on May 2014. The amount of 142.28 lakhs which was paid in 2014 was excluding the arrears of pay as per the 4th pay commission. The entire amount was not paid. They were paid in installments, so to say. They were paid in installments, but the entire amount was not paid. So therefore, the fixation of a cutoff date or a cutoff period is rendered meaningless. Now, our case here is, my lord, that we are still entitled, by their own admission, my lord, by the own admission of the respondent, we are entitled to be paid a sum of rupees 1,81 lakhs 15,481 with 2011 as the cutoff date. This is the amount to which they had agreed. Now our contention is, my lord, since we have worked till 2000, since the last payment, my lord, we worked till 2012. We attended office regularly till 2012. Our salaries were paid till 2010. Though we were given the golden handshake, we were not paid in one go. We were paid in three installments, that too not the entire amount. There is still outstanding amount of 1 crore 81 lakhs 15,481 as per the admission of the respondent government. And that too, this amount, if the VRS was, if the cut-off year was taken as 2011. However, the last payment being made on 2014, my lord, we are praying that 2014 be taken off as the cut-off date. And whatever is due to us be paid. That is why we are before your lordships. Now, my lord, it is not.
You see, when you realize that you have been paid only in 2014.
Yes, my lord. Thereafter, we have
made any representation.
Yes, my lord. We have made several representations, my lord. We have made several representations. We have had meeting with our employers, my lord. My lord, annexure, if my lord will come to annexure 9. Page 44 of the writ petition, my lord.
Yes. Yes.
Now, my lord, this is the minutes of the meeting held on 4/5/2016 at 3 p.m. in the office chamber of the Principal Secretary in charge, Commerce and Industries Department, in connection with the VRS of the employees of the Meghalaya Electronic Development Corporation Limited.
What was discussed and what was the resolution?
My lord, what was discussed was what is required to be paid. My lord, what is required to be paid, what would be the cut-off date, how the payments were made, and with regards the outstanding amount, what future course of action is to be adopted. No, my lord, I'll just read out the minutes of the meeting. The meeting was presided over by so and so, so and so, so and so. The chairman welcomed the members, so and so, so and so, so and so. Thereafter, a detailed discussion and deliberation took place on the important points which emerged from the discussions were as follows. Number 1. Well, point number 1. The government had directed the management of the MEDC to fix a cut-off date for VRS to its employees on the 31st of July 2011 as the cut-off date. To implement VRS, management submitted fund requirement statement to the government as per cut-off date, which was as follows. So, my lord, as per this, a total of 5 crore 45 lakhs 19,144 was the fund requirement as per 31st July 2011 at the cut-off rate, as the cut-off date. Now, my lord, against this fund requirement, the amounts which were earlier released was 1 crore 12 lakhs 20,000 released on 1/4/2010, and another sum of 1 crore 33 lakhs and 48,000 released on 15/4/2011. My lord, will find that at page 45. Now, after fixation of the cut-off date, which is the third installment, after fixation of the cut-off date, on 23/5/2014.
Yes.
On 23/5/2014, another sum of 1,42,28,000 was released. So the tabulation works as under that the total amount to be paid if VRS, if 31/7/2011 was to be taken as a cut-off date, was 5,45,19,144, out of which in 3 installments a sum of 3,87,96,000 has been released.
Yes.
So So, my lord, after this meeting held between the petitioners and the principal secretary in charge, Commerce and Industries Department, Government of Meghalaya, it was decided that the matter would be taken up with the government for consideration.
I don't understand. the last communication, as
Yes,
far as
ma'am.
the calculation of the BRS is concerned,
Uh-huh.
the revised BRS is 290.
My lord.
290, isn't it?
My lord.
290 plus. Eventually, as on 23rd May 2014, you have got altogether 3 crores 87. So that is more than what was supposed to be given.
No, my lord, it's not like that.
And what is this situation today? You have been paid this amount.
This amount of
My lord,
3
we have
crores-
been paid 3 installments, my lord.
3 installments, no doubt.
3 installments,
Whatever
my
the
lord.
case may be, but as of now, how much have you been paid? Was everything clear?
No, my lord. That is why we are before your lordship, my lord.
What? So, I mean, the whole amount is not yet.
No, my lord. It is not clear. It has not been paid, my lord. It has not been paid, and they are also admitting that it has not been paid, my lord.
No,
Now-
we are not
now-
admitting that.
But how?
My lord, I will,
We are not admitting.
How is the calculation made? I don't understand.
my lord,
I don't understand how the calculation was made.
my lord, the first installment was released on.
You see,
My lord.
just try to help me.
Yes, my lord.
Come back to your Annexure 4. Here the required fund, revised fund required
Yes, my lord.
is 290. So if
290,
290.84.
290 and 84. If
So if this amount is available, it would be sufficient to clear all your dues
to clear all my dues as on July 2011.
as on July 2011.
As on July 2011. So if this amount was paid as on July 2011, all dues would have been cleared. Now, my lord, out of this amount, the whole thing was not paid.
So out of this, see, let's go back.
Out of this, 114 was paid.
But in 2010, you have paid this 112.
No, my
Come
lord,
back to
this
page
amount
45.
this amount is excluding what was paid in 2009 and 2010.
Okay.
This is after fixation of the cutoff date. After fixation of the cutoff date, what was left to be paid was this amount, my lord.
What was left to be paid is 290.
Yes, my lord. If VRS was implemented on July 2011. But that was not paid.
That was not.
That was not paid. Out of this amount, what we received was 114. 114 No. Out of this amount, we receive 1,42,28,483 only.
Where is that?
My lord, it is there in Annexure 9, amount release after fixation of cut-off date on 23/5/2014. This was the amount release.
Where is it?
This is at page 45
45.
under the heading amount release after fixation of cut-off date.
Okay, amount release after fixation of cut-off date. So as on, exactly that's what I was saying. As on 23/5/2014, this was the amount that was released. 142.
142 was released out of that 294.
Out of that 290. 290.
No, yes, madam.
So where will this, what about this calculation of 387, 545
This will be clear if my lord comes to Annexure 12, my lord.
next year?
Annexure 12. This is again a letter to the
Page?
this is page 50, my lord.
Yes.
A letter by the respondent number 4 to the respondent number 5.
Yes.
I'll just read out. With reference to the subject mentioned above, we'd like to inform you that the following the session of operation in the year 2005, 42, this is the brief history, my lord. 42 factory employees out of the 59 were granted VRH under the Golden Handshake scheme. In July 2008, the government of Meghalaya advised the management to initiate steps to wind up the company and to apply for necessary funds for VRS GHS of the remaining 17 employees. As such, MEDC White letter number so and so dated 25th February 2009 submitted the fund requirement to the government of Meghalaya amounting to a sum of rupees 2,45,68,000 as on 31st March 2009, which also included salaries as per the third pay commission, as per details below. So on 31st March 2009, when a decision was taken by the government that the MEDCL will be completely wound up, a golden handshake scheme, a VRS or a golden handshake will be given to these 17 employees. Now, for the purpose of giving the golden handshake to these 17 employees, the petitioners herein, that is, including the petitioners herein, a sum of rupees 2,45,68,000 was required as on 31st March 2009. This amount included the areas of salaries as per the third pay commission.
Yes.
Now, the details are given as under. Now, my lord, that means if on 31st March 2009, the golden handshake was made, that means the entire sum was cleared, the employees were required to be paid this amount, 2,45,68,789. However, this did not happen. This did not happen on 31st March 2009. Now, it further reads, however, out of the aforesaid amount of 245.68 lakhs, the government released the following funds. So, my lord, on 31st March 2009, the admitted amount was 2,45,68,789 if paid on that day. But out of this amount, out of 2,45,68,789, the government paid two installments. The first installment was paid in the financial year 2009 and 10, which was a sum of rupees 1,12,20,000. The second installment was paid in the financial year 2010-11, where a sum of rupees 1,30,00,000 13 lakhs and 48,000 was paid. Now it reads as under, it further reads that further the government of Meghalaya, I stand corrected, my lord. Further, the government white letter number so and so dated 8 July instructed MEDC to submit a revised fund requirement as per the 4th Pay Commission. A revised fund requirement was directed to be submitted as per the 4th Pay Commission. Again, as advised by the government, the Board of Directors of MEDC in its 101st meeting held on 18th April 2011 decided that the cut-off year will be 31/7/2011. Thus, the fund requirement of rupees 2,99,51,144 towards VRS Golden Handshake scheme, which is inclusive of areas of salaries of 1,57,21,818 with effect from 1/1/2007 to 31/7/2011 being the cut-off date has been submitted to the government. However, in the financial year 2013-14, thus the government sanctioned a sum of 1,42,28,483 towards VRS GHS, this being the third installment. But an amount of rupees 1,57,21,818 of the area salary remains due to the employees. Further, we would like to clarify that while claiming the third installment, the area of salaries of the employee amounting to 12,58,000 was erroneously deducted from their total amount. We regret this inadvertent lapse on our part and request the government to include a shortfall of 12,58,446 as being a part of VRS GHS due to the employees of the MEDC. In this regards, the government has convened a meeting with the employees of the MEDC on 4th May 2016 and the government white letter number so and so has advised the MEDC to submit revised fund requirement taking into account also areas as per 4th Pay Commission amounting to 1,57,21,818. In July 2011, there was a 6% increase in dearness allowance and the same was not taken earlier in calculation of fund. In view of the above, the breakup of the said revised requirement as per Annexure A, Annexure B and Annexure 1 to Annexure 6 is given below. Now, this is the actual amount, my lord. This breakup of this breakup, which includes the amount decided in the meeting dated 4/5/2016, which is 1,57,21,818, shortfall in the third installment 12,58,446, an increase in VRS benefits due to 6% increase in dearness allowance, which amounts to 11,35,217. My lord, this is the breakup. Now, this breakup amounts to 1,81,15,481. Now, this is the amount payable to the petitioners had the same been paid on 31/7/2011. But that was not to happen. That did not happen. The last installment that was paid from the earlier computed amount was paid in the year 2014. So clearly, my lord, this is an admitted amount. There is no escape from this amount. However, my lord, our case is that the jural relationship between the employer and the employee continues till such time the relationship fully ceases to function. In this case, till the time the entire VRS is paid, now, which was not done. The last installment which was paid in the year 2014. Well, our prayer before my lords is that the respondents be directed to calculate a revised amount taking 2014 as the cutoff year, because their decision to take off July 2011 as cutoff year is rendered meaningless because they failed to pay the outstanding dues which was payable as on that date. So that being the case, my lord, and the last amount which was paid in 2014, we are making prayer before my lords that 2014 be directed to take into account 2014 as the cutoff year and pay our dues accordingly with all benefits as is as will be admissible in our case. Now, my lord, they have filed their affidavits. Now, in the affidavit, my lord, they have filed an additional affidavit, my lord. In the additional affidavit, reading of the additional affidavit will make it clear that it is not that they are not denying our liability, my lord. They are not denying their liability. They are only saying that because of fund constraints, they are unable to pay us. This becomes evident from the additional affidavit which was filed, on behalf of the respondent number 4. Now, my lord, what had happened was that when this matter came up for motion at the motion stage before Honorable Justice, Honorable Mr. Justice, thank you. Well, 2 queries had fallen from the court. Number 1, if the company was wound up, if the company was wound up, and what was the second query? And the second query was on the liability aspect. So on that, this additional affidavit was fine. Now, my lord, in this additional affidavit, it is very clear, my lord. Annexure 4 and 5 makes it very clear, my lord. Annexure 5 in the additional affidavit.
Dated?
This is dated 21st March 2018. Annexure 5, then Annexure 4.
No, your affidavit?
No, not my lord. This is the additional affidavit filed by the respondent number 4.
Who's respondent number 4?
My lord, the respondent number 4 is the Director of Commerce and Industries.
Affidavit was filed on 13th September.
My lord, sometimes in September 2024. My lord, these annexures running from annexure 1 to annexure 7 clearly, is very clear, my lord, that they are not denying the liability. The only thing they are saying is that fund constraint.
You see, if there is, let's say, if there's an admission on their part, and because of the fund constraint, maybe they would require some time. Have you discussed the matter with them?
My lord will kindly see that it has been shifted from one financial year to the other. There is, my lord, say for instance, annexure 2, which is dated November 2017, it says that with reference to the letter and subject cited above, I am directed to inform you that you are advised to come up again with the proposal for consideration in the last quarter of the financial year.
Yes, Ms. Yang.
Then subsequent there to.
I'm appearing on behalf of the respondents 4 and 5, MIDC and MEDCL, Your Lordship. And my
You're supposed to clear the area.
No, I am a subsidiary company, Your Lord. It's a corporation. And although my friend's trying to project.
My friend here appears for the holding company as well as for the subsidiary company.
And my friend here is trying to project these employees, the petitioners before Your Lordship, as regular employees of the government of Meghalaya, and that they are entitled to salaries or whatever compensation as per the 4th Pay Commission, Your Lordship. Way back in 2015, Your Lordship, the government has already said that this is the amount we have paid, and beyond that we cannot pay anymore, Your Lordship. And they have come here. But Your Lordship, today I have a little difficulty.
You have given your commitments.
I have not given any commitments to anybody, Your Lordship. These are only proposals.
In the correspondences.
No, these are only proposals put up to the government that these are things. It is not a commitment to the employees. They are only we can only make proposals as corporations because we have no fund of our own.
What we could picture is this: you are on the side of the employees, since they are your employees. You have committed. You have offered to them the scheme.
Because way back in 2013, only, Your Lordship, the board of directors of the corporation, Your Lordship, has said that whatever the government does, we accept that. because can only make proposals, Your Lordship, because we are not funding the employees, and our corporation had started sustaining a loss since way back before 2005, which is why VRS was given to the 42 employees out of 59, and the 17 were retained with the hope that we would be able to revive that corporation, but it could not happen.
So between you and the government, what was the commitment given?
The government has only given up to as per the Third Pay Commission, and they have stated that they cannot make any more payment, and that whatever fund is there, or their claim is already liquidated. We have already paid 387 point something lakhs, Your Lordship, to these 17 employees, Your Lordship. But they are claiming, as on 2011, the cut-off date, the amount was due was about 290, but because it was paid in 2014, 387 was given. Now, Your Lordship, their demand is not ending, Your Lordship. They had stopped working since 2010, yet they were paid salary, Your Lordship. This because of their, on humanitarian grounds, Your Lordship, let us say that, Your Lordship. Since 2010, they had stopped working, and then they were paid salary till then. Now they are saying that, every time we have paid more than 387 crores, Your Lordship, to 17 employees. But they have come with new supplementary demands that, no, you have not paid in one shot, you have paid in 3 installments, so you're due to pay us. But nonetheless, Your Lordship, today I have some difficulty, so I was thinking of making asking for a short, brief time, Your Lordship. Adjournment for...
Who's appearing for the state?
State...
Lordship, as my learned senior has stated, Lordship, it is a fact that the dues
as in 2011.
To the employees, Lordship, has been cleared, Lordship, to the year 2011, and the areas due to them...
So you're ready to be heard? Should we take up...
Should we take it up
who's
together, Your Lordship?
It has to be taken up together, Lordship.
Because there are many documents and minutes of the board.
I'll file short bullet points, my lord.
You can do that.
Whatever my friend has submitted right now is contrary to what is there in her affidavit.
Anyway, we'll see.
Anyway, when the matter comes up for hearing,
because I feel that he has not given a correct submission before Your Lordship, which is why I want to go deeper into my thing. This matter had been taken up earlier before Justice Mr. Thank you. It was heard at length, and then again it has been...
That is why the additional affidavit came and the admission.
There's no admission, Your Lordship.
There's no admission.
There's been misinterpreted
we'll look into it
by my friend.
Or Mr. K.C. Gautam, Learned Counsel for the petitioner. The respondents has sought for time to respond to the said argument. Accordingly, matter is now posted after
2 weeks, Your Lordship.
1 week?
2 weeks, Your Lordship.
1 week will be good enough.
10 days, my lord.
2022 matter.
Yes,
Between 10 days and 2 weeks, no difference.
The delay has not been caused due to us from our end, because my friend here was unwell, so it had to be...
This is matter for 2 weeks.
2 weeks. Obliged.
Item number 5.
Here I am a private respondent, my lord. Although, my lord, the matter had come up last week, and I prayed for a week's time. But the only difficulty is that, my lord, I have misplaced the file, my lord. So if it is kindly taken up on any other date. My apologies, my lord.
No objection.
I'm presented by Mr. K.P. Vastaji.
I'm for private respondent number 7.
Learned Counsel for the respondent number
7.
7, seeking accommodation on grounds of personal difficulty. Matter same not be objected to by the petitioner. Matter is adjourned. This is after 2 weeks.
Obliged.
Item number 6.
My lord, I would like to seek some accommodation on this matter, my lord.
Why you have not made a prayer in the
Mr.
mentioned...
Yobin is unwell, my lord.
You should have made a prayer in the mentioned hour.
My lord, there was only 6 items. They just started with the date release. They didn't call up for. They mentioned. That's why I
See,
waited.
it's not question of being called up. Once the court, sits, you can always that would be the mention.
My apologies. my
It's
lord.
not necessary that we have to, announce.
Yes, yes, my lord.
Because sometimes, the court master would wait for some time,
Yes, yes.
allow the counsel to come. Anyway,
My apologies, my lord.
I have no objection, my lord.
Mr. Letter Counsel for the respondent has sought for accommodation on the ground on personal difficulties faced by the counsel who is leading this case, faced by Mr. P. Owen, Letter Counsel, who is leading this case. The petitioner not objecting to the same, pray aloud. When?
2 weeks, my lord.
Premier, let's this matter up to 2 weeks.
Obliged, my lord.
Second call, item number 1.
The stage of the case is, what is the stage?
Trial, Your Lordship.
Evidence. How many witnesses have been
Till the filing of this insana application, none of the prosecution.
How many witnesses are there?
8 cited witnesses, Your Honor.
8.
8 cited.
When were how many charges? When were the charges framed?
The charge was framed on 30th of September, my lord.
30th September. And how long have you been in custody?
Almost 9 months.
9 months.
9 months.
Charges, Mr. Guru. Charges framed in September 2024.
That apart, my lord, the witnesses here, my lord. We have 6 of the witnesses from the government and 2 are independent. It won't take much time, my lord. My lord, having said that, my lord.
It won't take much time, but why have you not started?
That is there, my lord. Whether it is, if it had not started, my lord, whether it is attributable to the prosecution or the defense, that also has to be seen, my lord. That also be seen.
That, of course.
Yes. Now that apart, my lord, in a case, my lord, I don't have to, my lord, make an elaborate submission. Lordship is very clear on that. My lord, we have to see whether the petitioner herein, my lord, whether there is.
Let him state his case.
Oh, yes,
you can respond.
my lord.
May it please your lordship, I reconcile on behalf of the petitioner, Waris Uddin Laskar, who is the paternal uncle of the accused, Shaheen Hussain Laskar, my lord. My lord, the fact of the case that on 24th of June 2024, that the complainant SIASR Lakiang received an information from Additional SP B. Dingan, MPS Additional SP of Cleriat. So on that day at 9:30 AM, he received an information that one drug peddler by the name Rafiqul Alam Laskar is coming from Silchar towards Shillong, suspected to be carry along with him with some contraband. So a Naga check gate was set up at Naurim Hills village in Santia Hill district along with staff and all other police officers. And at 11:30 AM in the morning, they intercept one suspected white vehicle bearing registration number so and so. And while checking the vehicle, it was found that the person who have been named in information was present, very much present in the vehicle. So during the search of the vehicle, it was found there were 3 occupants of the vehicle, my lord. 2 male and 1 female. So during the search of the vehicle, nothing was found from the vehicle, my lord. And during the search of the body search of all the occupants of the vehicle, from the female body, that is Srimati Mayagwala, it was found 15 cases of suspected contraband heroin. It is is amount to 164.99 grams, which fall under intermediate quantity, my lord. So, my lord, that during the interrogation, that this Srimati Mamta Sinha revealed that this contraband was instructed by the Rafiqul Alam Laskar, in this case, who have been named in the information, also found in the vehicle. He instructed her to keep the suitcases inside her body. And also she said that these contraband were meant to be transported to Shillong to one Srimati Mayagwala from Shillong, my lord. So on that case, my lord, that they were arrested at the PO, and later stage, the co-accused who conspired and also financed the case, my lord, Mayagwala, also were arrested from Clariat on the 24th of on June 2024. And after that, my lord, they were sent for remand to judicial custody on the next date, my lord. My lord, after the investigation was completed, the IO filed a charge sheet, my lord, on the 19 August 2024. While charging the case, my lord, there are different sections. There are different sections on charge against the accused person and against the accused person, my lord. And while furnishing, my lord, the charge sheet before the trial court, my lord, the IO prayed before the trial court to allow him to file a supplementary charge sheet when he obtained the FSL.
When was the charge sheet filed?
Charge sheet was filed on 19/08/2024, my lord. On 19 August 2024.
Yes.
And while furnishing your, my lord, the charge sheet, and there was no FSL. So, my lord, in order for a clear and convenient submission, my lord, I would like to refer these 4 accused persons in numbers. My lord, that the prime accused, that is Rafiqul Alam Laskar, accused number 1, Srimati Mamta Sinha, accused number 2, from where the contraband was recovered, and Sahin Hussain Laskar is the present accused in this case, and Srimati Mayagwala is accused number 4, my lord.
Yes.
And subsequently, my lord, that the after the argument before charge, the Honorable Special Court has framed the charge against me on the 30th of September 2024 under Section 21B and Section 29 of NDPS Act, my lord. My lord, this is the first bail application, and during the period that I have been incarcerated, my lord, that I have been preferred 4 occasions of bail application before the learned special court at Clariat, my lord, but it was found to deem fit to reject, my lord. My lord, I prefer this instant bail application as I have mentioned in my petition, page number 6, para number 8. The contention, my lord, that
yes.
The contention, my lord, this instant bail application. The first one is that the case is already charge-sheeted. Charge against the accused person have been framed and the case is pending for evidence till date. The date of filing of this instant bail application, none of the witnesses out of 8 cited witnesses proposed by prosecution. Number 2, my lord, that the alleged suspect contraband heroin recovered is of an intermediate quantity. Number 3, my lord, that the rigors of Section 37 of NDPS Act is not being applicable. Number 4, that accused number 3, my lord, have a clean criminal antecedent and no criminal records known against him. Number 5, my lord, that I have been languishing in the jail for more than 8 months, my lord. That till date, the FSL have not been furnished. And moreover, the last, my lord, that the prime accused have been enlarged on bail by the learned special court, my lord, only after 3 months in custody, my lord. Further, my lord, in order to substantiate my contention, I would like to further submit, my lord, that the case has been charge-sheeted, my lord, and the case has been charge-sheeted, and the frame also has been charged, my lord, and till the date of filing this bail application, my lord, none of the prosecution the prosecution witness has been examined, my lord. So, my lord, that provided that, my lord, since I have been already 8 months, more than 8 months, almost for 9 months, my lord, in jail, so even my custodial interrogation also is not required anymore. So, with the circumstance arise, my lord, from this instant case, it is there is no possibility that in near future the conclusion would come, your honor, my lord. So further incarceration of the accused, my lord, may infringe his basic right, my lord. And further, my lord, that the quantity of the contraband involved in this instant case is of intermediate quantity, is 164.99 grams, which was recovered from 164.99 grams, which was recovered from the one of the occupants of the vehicle, my lord. Therefore, in such instant, my lord, as your lordship is very much well versed that when such case of intermediate, that the rigors and the condition of section 37 is not being applicable against me, my lord. In this instant, my lord, also I have mentioned in my page number 7 of my bill application that, my lord, this Honorable Court also have observed in case of Srimati Lily Siltau with the state of Meghalaya, my lord, where the relevant paragraph, my lord, number 10, my lord has already observed that section 37 is not being applicable. Case number 1, my lord, Lily's seat how was the state of Meghalaya, bill application 55 of 2023, dated 16/11/2023, my lord, in para 10, my lord, where you, my lord, have observed that since the case of intermediate quality, section 37 is not being applicable. Yes. And also, my lord, that since the charge sheet has already been filed and the case is taking up for trial before competent court, at this point of time, it will not be relevant for further detention or detain the accused person in custody. And further, also, my lord, in the case of Srimati Lakantiu Risa Nongrum and others was the state of Meghalaya, bail application 2 to 5 of 2024, dated 16/02/2024, my lord, have observed the same, my lord, in para number 4, case number 2, my lord. In para number 14, my lord, considering the fact that the accused person have been in custody for quite some time, investigation has been completed, and the charge sheet have been filed, and evidence is ongoing.
Yes.
Yeah, is ongoing. Only 1 out of 9 witnesses have been examined so far. So the possibility of the trial being concluded within a short span of time from date is remote, my lord. Here in this case, there were six cited witnesses. 1 has been already examined, and my lord, you have already observed that since the case have been charged sheeted and the possibility of the trial being concluded within a short span of time from the date is remote, my lord.
Yes.
And also, my lord, in the same case, Srimati Lakantiu Risa Nongrum and others, Supra, my lord, your lordship also have observed and consider the observation made by the Honorable Supreme Court in the case of Sanjay Chandra, my lord. And in this case also, my lord, even in my case also, my lord, that since a bail application generally has been laid down from the earliest time, that the object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail, my lord. So the object of bail is neither punitive nor preventive, my lord. This case is of intermediate, and I have been incarcerated for more than 8 months, my lord, and all the cited witness also, my lord, have not been examined on that time. So in this regard, my lord, I refer to all the judgment, my lord, that has been observed by your lordship. The other limb of my contention, my lord, in regards with the FSL, my lord. My lord, FSL is one of, till date, the concerned IO of this instant case have not furnished the FSL, the chemical analysis of the case. My point of argument here, my lord, now the FSL report is the essential and integral part of the prosecution case. In absence thereof, my lord, render the prosecution case. NDPS case, my lord, is only through the reports and chemical analysis can confirm that the contraband is of illicit.
As far as that is concerned,
yes, my lord.
Number 1, the IO had sought for permission to file the
yes,
supplementary charge sheet.
Yes, my lord.
That has not been done.
Not been done, my lord.
it may be done eventually. In course of time, it will be.
Yes, yes, my lord.
If he has sought for, time to file a
Yes, yes, my
FSL
lord.
report, then it will be done.
Yes, my lord.
So I don't think we should consider that aspect of the matter here.
Yes, yes.
And
I'm
in
not.
any case, that would be, you see, a question of evidence
Yes,
as
yes,
far as
yes.
the trial is concerned.
Yes, 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 my lord.
Bail matter would
Yeah,
should not be confused.
what is my concern? I'm not saying that, my lord, just because such it has been charged without FSL is not a complete charge sheet. My question is here, my lord, there are so many judgment and observation made by the different high courts, even Supreme Court, even this honorable court also have observed it in one case, my lord, that in the event of absence of FSL is not, because that question is still languishing in the before the honorable Supreme Court of India, my lord. So in the event, in absent, my lord, it's always, even the Supreme Court also, even the High Court also, my lord, that they grant bail in the observation and considering that the time that the person or accused person have been languishing in jail, my lord.
That would be only on the premise of the case being prolonged or delay in proceedings.
Yes, my lord. So in my case also, my lord, I have been almost 9 months. So that is one aspect also may be considered in my case, my lord. So I have also referred, my lord, in the in my bail petition, my lord, paragraph in the page number 9, some of the cases that I have been cited where they grant bail, my lord, and even the Supreme Court also have granted bail in case of Divyas, my lord, in this regard, where they grant bail in this regard.
Yes.
Though the question of law is still pending before the before this honorable Supreme Court, my lord, but the grant bail on aspect that considering the amount of time that the accused has been in jail, my lord. That is, considering the amount that the accused has been in jail.
Where is that observation?
My lord, I have in the page number 9, my petition, and paragraph number 1, 2, 3. Whereas the Honorable Supreme Court in special leave to appeal number 11628 2022 white order dated 01/05/2023 has granted bail to the petitioner, taking note that the petitioner have been in custody for some time and the trial would take some time to conclude, my lord.
Of course, this.
And even my lord also have observed in certain cases, and the Madhya Pradesh also have observed in many cases, my lord, I have mentioned there. With consideration of the time period that they have been in custody, my lord. Where in case of Divyas, my lord, even the Honorable High Court of Madhya Pradesh have observed it many times, my lord. With consideration of the time that the accused has been in custody. So I'm not praying, my lord, since the question of law is languishing before the Honorable Supreme Court, my lord, I'm not submit that I should be getting bill from because of FSL or such it is completely clean, but on consideration that since FSL also has not been completed, I have not been furnished, and also I have been in jail for quite some time, my lord. So my additional contention, my lord, as I have mentioned in page number 10 of my bill petition, my lord, that the accused number 1, the prime accused in this case, who conspired the case and who also planned the case, my lord, have been enlarged on bail. Since only after 3 months he was in custody and he was enlarged on bail, my lord. My lord, here, since he was enlarged on medical ground, I'm not contending on parity, my lord. But the question is arise here, this person who have been enlarged on bail has been charged under section 27A, my lord. So section 27A is much applicable in section 37. So all the rigors of section 37 and all the condition has to be fulfilled by the accused, then he can be granted bail, my lord, because he has been charged under section 27A. So 27A is fall under the rigors of section 37. Now this person who framed the prime accused is enjoying his liberty on bail, while I am the victim of consequences and circumstances. I'm languishing in the jail, my lord.
You see, when a person is sick, you're saying he's enjoying.
No, from that aspect, I'm not saying. He's on bail, my lord, only after three months in custody.
But the grounds, like you have pointed out, was on the ground of sickness. we don't know what is the gravity of the sickness, but we would assume it is the wisdom of the court concerned
Yes, my lord.
to have granted him bail. So, and you have not pressed for party, which cannot be
It cannot
you
be.
know,
Yes, my
equated
lord.
in any case.
Yes, my lord. But what is my contention that, my lord, since this, I am not charged under section 27, I'm charged only as section 21B and 29, my lord. So, considering the charge and the role play in this instant case, my lord, I am at a better footing, my lord, against the accused person who have been enlarged on bail, though it is on medical ground, my lord.
Yes.
Yeah.
My lord, before I make my submission, my lord will appreciate that this is one case, my lord, particularly under NDPS, my lord, that it has the tendency to, my lord, it is to destroy the entire society, my lord. That is one thing, my lord. Secondly, my lord, about the involvement of the accused herein, my lord. His own statement, my lord. Kindly, my lord, if I may take your lordship to page 57, my lord. Shaheen Hussain Laskar, page 57. If I may read, my lord.
Yes.
23rd 6, 2024, Sri Rafiqul Alam Laskar came to me and told me to drive his vehicle to Shillong as he was a cancer patient. And also, he is my friend, so I agreed. And he told me to deliver the drugs at Shillong City Polo Market along with him and his worker Srimati Mamta Sinha, in which she concealed the consignment on her waist below her thighs, to his girlfriend Srimati Maya Gaula in Polo Market, Shillong, and promised me that he will give me big amount of money after delivered the drugs. And I used to go with him 2 to 3 times before for the same purpose. That's all I have to say. Now, my lord, the very statement of the petitioner here in my lord reveals that he was very conscious about his involvement here. Rather, this was the third or the fourth time he had been doing this, my lord. That is one thing, my lord, about his involvement. And if he is released on bail, whether he will repeat the offence again, it clearly shows that he is going to. Now, that apart, my lord, kindly come to the statement of the main accused from whose body the drugs was being, my lord, seized.
Yes.
That is page 56, my lord. Mamta Sinha. If I may read, my lord.
Yes.
I am a shopkeeper. I work under the ownership of Sri Rafiul Islam Laskar since 3 years, and I stayed in Singarai, Bita Bichia on 23/6/2024. My owner Rafiqul told me to go along with him to Assam to his native place for some urgent work. So I believe him, and on the evening time he gave me the consignment to tied in my waist down the thigh and promised me after deliver the drug he will give me rupees 5,000. More so, I agree and travel along with him. And his friend Sri Shaheen Hussain, he is the petitioner here. And his friend Shaheen Hussain Laskar from Silchar, Assam, but on reaching at East Jaintia Hills district Meghalaya, I got caught by Meghalaya police, who are on Naka checking at the Nongri Mills village near the police Naka checker. So, my lord, from the statement of the man accused from where it was seized, my lord, that apart, my lord, it is my lord, further fortified by the very statement of the my lord petitioner here in that he was involved in this peddling of drugs, my lord, out of his own choice, my lord. That apart, my lord, now my friend is moving this bail application on the point on one ground that he has been languishing in jail for about 8 months, my lord. My lord had passed a judgment, my lord, in a bail application, my lord. It is an intermediate quantity, and where, my lord, the accused person was inside the jail for 9 months, my lord. And my lord, there, my lord, have make a very specific observation that this is a case where, my lord, drugs is such a menace that it is destroying the society, it is eating up our society in a rapid manner that has to be dealt with an iron fist, my lord. That is reported in, my lord, bail application number 22 of 2023. Judgment date is 31/07/2023. Shri Khuplinchan Sum versus State of Meghalaya, my lord. My lord, I'll just provide, my lord. It came into
If you
my
are
mind.
relying on some
Yes,
authorities, you have to.
I'll provide just now, my lord. I've sent my junior, my lord. Now that apart, my lord, for the sake of argument, what my friend has stated, my lord, about the passing of judgment, granting of bail by High Court of Allahabad or High Court of Punjab, my lord, there are conflicting judgments, my lord, from different high courts, my lord. What we are bound by is, my lord, the judgment that has been, my lord, passed by this honorable court, my lord. Now, my friend had raised the point of, my lord, official, my lord, that at the time of filing of the charge sheet, that, my lord,
he is not pressing on.
Okay, they're not pressing. Then in that case, my lord,
for the fact that this issue is under consideration by
my lord, finally, my lord, my friend's argument is that the main accused, not who is allegedly to be the owner of the, my lord, consignment, my lord, he was released. But apparently, from his own statement, the main accused is a cancer patient, my lord. So it is a very serious, my lord, disease. Hence, my lord, court took a very lenient view on that. So he is in treatment right now, my lord. So he cannot be, my lord, we cannot be, my lord, the bail order cannot be, my lord, painted with the same brush on all the accused person, my lord. My respectful submission would be, my lord, I have got a very, very strong, my lord, objection for grant of bail in this case, my lord.
This Manta Singha,
yes, my lord.
She has been enlarged on bail, or she's
No, she's still in jail, my lord.
Because the alleged contraband
was
found from her.
Yes,
she's still in jail, my lord.
Yes. It was found from her.
Only that the driver, the
owner, Rafikul, who is the owner of the.
He was also in the vehicle.
Yes, even he also was in the vehicle. He's the one, Rafikul, who has been enlarged on bail. Information was received that he is the drug peddler.
Right. So there are three occupants. All three have been arrested.
Yes, my lord.
One has been released on bail. Two are still in custody.
Yes, petitioner was driving the vehicle.
And another one was arrested at a later stage. He's still in jail. My lord, that I just want to mention, if I may, whatever the citation or the reliance put by my learned friends, since I cannot supply with you, my lords, as I also have supplied the observation made by your lordship in the case of Lakentiu Risa Norum, my lord, instead of Meghalaya. This bail application recently last year only, my lord, that these people they were caught with the intermediate county in the taxi, my lord, and these people they were caught red-handed. And however, my lord, that after 9 months they prepared the bail application before this honorable court. It was granted, my lord, on observation of the case, on observation of the Sanjay Chandra case, my lord. So at the same time also, my lord, since I'm about to be nine months in jail, my lord, I'm not. I think it's already briefed by my learned friends about how the settlement also. This is a question to be a question of trial whether I involved. No, as of now, 161, my lord. Even from all the 161 also, my lord, I'm not the prime accused in this case, my lord. Rafikul is the main person also, my lord, in this case. I was just, my lord, stated by the prime accused that I will give you something. Because what happened, my lord, I was about to get married. So without knowledge of such consequence of the case, I'm willing to drive the vehicle. Even Mamta also stated the same. I also stated the same. I confess, my lord. So in the event, even I have preferred the bail application before the Honorable Trial Court on the 4th bail application on interim relief, since my marriage was scheduled on 17th of 12, 2024. Only after that I will come back to jail. But it was not deemed fit to release, my lord. Because this instant I'm just a victim of the consequences without knowing the consequences. All the accused, even the statement of the co-accused also stated the same. My statement also, I have confessed, my lord, if that is to be considered. Even the the prime accused also, my lord. I'm not the main person who have been involved in the case. Moreover, my lord, this is an intermediate quantity. So the question of the question, my lord, that the general principle of bail may be considered to me, my lord. My lord, that the question arises also, my lord, that I am charged only section 21B and 29, my lord. This particular, the case in this instant case against me, my lord, is not fall under the parameter of the offence, which is punishable under the more than 10 years or life imprisonment, my lord. This case, if that is the case, that I may be convicted or not be convicted, that is a subject matter of trial, my lord. But I'm still at the stage of to be considered as innocent, my lord, because the section charge is up to 10 years only, my lord. So Sanjay Chandra and all the relevant observation of bail jurisprudence may be considered when granting the bill on me, my lord. So in the event, my lord, that in the case that my friend has said that I may continue or the offence again, my lord, now even this honourable court can put a condition that I may give my contact number and even location to the IO also, my lord, in the event to prevent me, for instance, for such anxiety from the prosecution, my lord, that can be redressed by strict condition, my lord. So, my lord, I pray before this honourable court to grant me bail on in term and condition. My lord, in the event that I'm granting bail, I shall furnish reliable surety to satisfaction of the honourable court.
My lord, my friend here is, my lord, painting a picture of innocence of the petitioner, my lord. His very statement says that he has already done 2 to 3 times before, my lord. So, my lord, that has to be taken into account, my lord.
My lord,
he's a habitual offender, my lord.
My lord, my innocent here, I'm not saying that my innocent here is different aspect what I mean, my lord. Innocent here, that from the aspect of intermediate quantity, where general principle of bail has to be considered as many cases is there, my lord, that when it come to intermediate quantity, my lord, that the presumption of innocence is all the jail is an exception, my lord, in case of intermediate quantity. If I may point out, my lord, that one more thing, because my lord friends has said that he considered that the sickness of the accused person was cancer. As per the bill granted, he was suffering from chronic calcific pancreatitis, my lord. Just to mention that.
That is case.
Anyway, all the accused have been charged with the offence of, or rather booked with the offence under section 21B.
No,
Intermediate.
no, even one accused may fall also 27A. Because 27A is for financing the illicit contraband, my lord. That's fall under 237.
Where is that?
In the, my lord, I have
in your charge sheet, in the charge sheet?
Charge.
This is the conclusion at page 24.
Page 24.
B, my lord.
Only 21B.
No, framing of charge is there, my lord.
Oh, framing or charges are in frame.
Yeah.
Where is it? Where are those?
It's page number 26, 27. 27, page number 27, my lord. According charged with 2 heads under section 20.
Okay, only against. Where's the FIR?
No. Page number 14, my lord.
heard Mr. Letter Counsel for the petitioner, who has submitted that on 24/6/2024 at about 11:30 a.m. the vehicle bearing registration number AS01 EJ 8977 occupied by 3 persons, was intercepted by the police at a place called Nogram Hills on the NH 06. On the said vehicle and the occupants being subjected to search, certain amount of alleged contraband substance was seized from the person of one of the occupants of the said vehicle. Accordingly, on an FIR being lodged by SI ASR Lakian of Cleriat Police Station, being lodged before the officer in charge, Cleriat Police Station, East Jaintia Hills District, by the police have arrested all the 3 occupants and investigation was launched. In course of investigation, it was discovered that the seized contraband item was identified as heroin amounting to 164.99 grams. The IO, after completion of investigation, has filed his charge sheet with the opinion that a prima facie case under section 21B under bracket B small b oblique 29 NDPS are found well established against the arrested accused person, namely Srimati Mamta Singha, Shri Rafiqul Alam Laskar and Shri Sahin Hussain Lashkar. 4 or 3? Then this Maya Gwala, she has not been arrested.
She was arrested.
Arrested, my lord, because she was the one to receive the consignment, my lord.
So there are 4 persons.
4.
Okay. So on to 3, isn't it? Stop. Another person, namely Srimati Maya Gwala, who is said to be also part of the racket, was also arrested in connection with the case. The matter came up for framing of charge before the Lorette Trial Court, wherein charges were framed under section 21 under bracket B oblique 29 of the NDPS Act, and the additional section of 27A was also framed against the alleged main accused, Shri Rafiqul Alam Lashkar. The learned counsel has submitted that this instant bail application has been filed by the petitioner on behalf of the accused Shri Shahin Hussain Lashkar. The argument and contention raised by the learned counsel in support of his pleadings in this petition is that the accused person in question has been arrested in connection with the said case, aforementioned case, and is in custody for about 9 months or so till date. The charge sheet as well as the charges have already, the charge sheet having been filed and the charges also framed against the said accused. Therefore, there is no requirement for any custodial interrogation or questioning. Secondly, since the charges have been framed and trial is proceeding, therefore there is also no possibility of any of the accused tampering with the evidence or witnesses as far as this case is concerned. The fact that the alleged contraband substance seized was of intermediate quantity in accordance with the provision of section 21B of the NDPS Act. Therefore, the rigors of provision of section 37 is not applicable. As such, the general principle of bail may be applied to the case of the accused person in question to say that bail is the rule and jail is the exception. In support of his case, the learned counsel has cited a number of decisions passed by this court as well as by other high courts. Excuse me. I can get to contact. Excuse me, I'm having this allergic attack.
My lord.
Becomes very awkward. We have to.
This is the season, my lord.
What to do? I can't. It's not my doing.
My lord. Absolutely.
To go. Wherein, in the case of Lily Still How versus State of Meghalaya in BA number 55 of 2023, in its order dated 16/11/2023, this court at para 10 has observed as follows. Again, on the issue of on the aspect of the case being prolonged or delayed, in as much as out of how many witnesses?
8 cited witnesses, my lord.
8 cited witnesses. None have been examined so far.
My lord, if I may, last I think, if not mistaken, it was fixed on the 11th, 12, and I came there due to unknown reason. Witness was there, I was there, but person was absent. So it was fixed another 2 days later. It was fixed on Saturday, which I have already scheduled because I have a synod in my.
No, but the point is, no witnesses have been examined.
No, on that day, if not mistaken, one witness, this Saturday, one witness has been examined, my lord.
One.
Yes, my lord.
Kunung Tukong? Yeah, 8 cited witnesses. Only one witness have been examined so far. That is on
Saturday.
15th.
15 years, my lord.
15/3/2025. As such, the conclusion of the case, the conclusion of the trial may take some time, which would thus enable the petitioner to seek for grant of bail on this score. The Learned Counsel has further referred to para 15 of the said Tiurisha case, Tiurisha Norum case, wherein this court has relied upon the principle cited by the Honorable Supreme Court at para 21 of the case of Sanjay Chandra versus CBI, reported in 2012 1 SEC 40, to say that bail is generally granted if the appearance of the accused person could be secured at his trial by a reasonable amount of bail. There is also next the reference to the prayer of the IO for filing of a supplementary charge sheet on the ground that the FSL report could not yet be filed before the court. The Learned Counsel has cited the case of Divya Bardeva, wherein the Supreme Court is this on the issue of FSL?
Yes,
Not
my lord. It was on the issue of FSL, but later observed because.
In this case that you have cited.
Yes, my lord.
It's only on the
consideration because the accused has been in jail for some time.
Yeah, this is okay. That is okay.
Okay.
Untuk orang tu? the Learned Council has submitted that on this ground too, bail has been granted to the accused person in question, to the accused person therein, by relevant order of the Honorable Supreme Court as well as many high courts in the country. However, since it is also the admission of the Learned Council that this issue is under consideration before the Honorable Supreme Court, and as such, bail on this ground is not pressed for.
That pending before the Supreme Court, my lord, that is the case of Mohammad Arbaz versus State of NCT, New Delhi.
That is still pending.
Similarly, Arbaz Khan and Divyas, they have clubbed all special leave the club.
Many, my lord.
On the issue of FSL,
Yes,
it was clubbed together, my lord, in this case.
in this case,
Yes, my lord.
you have the citation with you? I mean
I have the
case number.
Case number I don't have, but this is famously known as Arbaz case, my lord.
I remember that case, but the case number, if it's not there, then
All these pending special leave before Supreme Court also they have granted bail, my lord. It's only subject matter of question of law. Left, but they all have been granted with bail.
no, bail could have been granted on other consideration, but not necessarily
Not
on
on that, my lord.
It is like that Tufan.
Yes,
case, see, where
my lord.
the issue of Section 67 has come in.
Exactly, my lord.
So that matter also has
My
proceeded before Supreme Court, and all other proceedings in all over the country has been stalled as far as that
point
is concerned. Anyway, we'll not go into that.
My lord.
How old is the accused person?
26.
26 or 36.
The Learned Council
29, my lord.
29.
has submitted that the accused person in question is a young man of 29 years old who is about to get married, his marriage having already been arranged and fixed. Therefore, it is prayed that this petition may be allowed and bail may be granted to the accused person with any strict conditions as deemed fit and proper to be imposed by this court. Per contra, Mr. R. Gurung Leonard GA has strongly opposed the prayer made on the ground that the facts and circumstances of the case would show that the accused person in question is very much involved in the whole operation and is very much aware and is also aware of why he has also very much aware of the reason he had proceeded along with the other two accused persons in the said vehicle. He is aware that the contraband substance and the bracket heroin was in the possession of one of the co-accused person who is who was a co-passenger with him in the said vehicle, And in fact, in his statement under section 161 CRPC, he has admitted that he has agreed to proceed to Shillong in the said vehicle along with the said co-accused, and also had also given the name of the other co-accused person to whom the said consignment was to be delivered at Shillong. The accused person in question has further admitted that he is involved in such similar operations for about 2 or 3 times before he was arrested. Next. Taking into account such admission and the fact that the society at large is wary of the prevalence of drug-related incidents and cases, which has destroyed the very fabric of society, particularly the lives of many who have been lured and addicted to such contraband substances. Therefore, this court, taking into consideration such a situation, may not allow the prayer of the petitioner as far as this instant case is concerned.
My Lord, I have relied on that judgment. Is there? The relevant paragraph would be 18, 19 and 20. Is page 7, my Lord. That is a now Lordship had taken a cue from the Supreme Court, my Lord. 18 onward, 18, 19, 20.
The learned J has also cited the case of Sri Kuplian Sum versus State of Meghalaya, wherein this court, by order dated 31/7/2023 in BA number 22 of 2023 at para
18, 19.
18, 19 and 20 has observed as follows. It is therefore prayed that this petition be devoid of merit. The same is to be dismissed. This court has given thought to the argument of the parties, of the learned counsel of the respective parties. Facts as stated above need not be repeated. What is to be considered is whether a case has been made out for grant of bail as far as the accused person in question is concerned. It's granted the case is at the stage of trial with only one witness being examined, with only one witness out of 8 cited witnesses being examined. However, as far as the reliance on delay in the proceeding is concerned, this court is of the considered opinion, and this court is of the view that there has not been any delay as far as the proceedings is concerned, since by the own admission of the petitioner hearing, the learned trial court has brought on record the evidence of one witness as recent as 15 March 2025.
My lord, if I may, that the case was fixed on 13th. It was fixed on 13th for evidence. That's mean last week after filing the base application for evidence. I was there, very much present. The witness also was there, and prosecution, I don't know what happened, and he could not appear. So immediately after 2 days itself, it was scheduled. So on that day, my lord, I have already scheduled my but I have not cross-examination the witness.
It only shows.
But his examination in chief was recorded.
Yes, was recorded.
It only shows how meticulously the court is proceeding.
Though the cross-examination of such witness is yet to be completed. Be that as it may, there is no reason for this court to believe that the trial has been unnecessarily delayed. Given the antecedent of the accused person in question, the petitioner cannot resort to the principle laid down in the case of Sanjay Chandra Supra, since in the opinion of this court, considering his own admission of being involved in such trade on a regular basis, therefore, if granted bail, he may prove to be a flight risk. The submission of the learned counsel for the petitioner in this regard would not help his case, as a delay of 9 months, as being incarcerated in custody for a period of 9 months or so, would not by itself constitute any inordinate length of delay, constitute any prolonged length of delay. Accordingly, the authorities cited in this regard is not found applicable as far as this case is concerned. Next, in view of the findings and observation made here and above, this court is convinced that this petition deserves no consideration. The same is hereby rejected. Before parting, this court would request the Direct Trial Court to proceed with the trial. Proceed with the trial expeditiously. We'll see after 2-3 months. If the trial is not, if evidence is not recorded, can come back.
Deeply well.
Thank you. Petition disposed of.